Good afternoon. I'd like to offer a very warm welcome to all of the accountants, the lawyers, the business owners in attendance. We very much appreciate you joining Quantum Tax Law. Our consortium program deals with various different methods of surviving the economic crisis that's befallen all of us. I'd like to start off by just giving a little bit of background. For instance, the International Monetary Fund has made various statements with respect to the current crisis in which we're undergoing. The statement that we've heard from the IMF, International Monetary Fund, is that the world's economies are in a crisis like never before. Canada is in the midst of the largest economic contraction since 1921. I realize there are a lot of anxious people on the program today, and we do not intend to sugarcoat these issues at all. As a matter of fact, we strongly urge you to consider the likelihood that there will be widespread insolvencies and bankruptcies in every sector in Canada over the next 12 to 18 months. Most of you in attendance who are accountants and lawyers are here because you're looking for solutions that are not common, perhaps solutions that may not even exist in most of the planning that you might get involved with. How many of you accountants and lawyers in attendance today are receiving calls from anxious clients, people who are desperate, looking for answers? And what kind of advice are you giving them by extension? Well, today we've assembled some of the top tax and finance experts in Canada and internationally in order to provide innovative, unique, and compliant solutions that can help to weather the storm that lies ahead. During these critical times, it's actually, in our view, incumbent on professional advisors to be able to embrace solutions and to be proactive in offering advice. This is a moment of honesty. Accountants and lawyers are not always proactive, are they? Clients who come to you looking for solutions are not likely to do so if they're not aware that the solutions even exist. For those of you who are business owners, we appreciate the difficulty that you're suffering, and we'd like to offer help for those of you who have come to the conclusion that your financial security may be unexpectedly threatened over the last little while. We appreciate you joining the program, and we're intending to discuss 3 different issues through our expert panel. The first issue we're going to be discussing would be methods of protecting assets against future creditors during a time when insolvencies are likely over the next 12 to 18 months. We will also be talking about, as our second point, ways of taking advantage of a downturn in an economic crisis in order to gain tax advantages and to help your family and your business survive and be able to mitigate the effects of taxation. Third, we would like to provide for succession ideas for your family insofar as you're able to do planning that can allow you to bring family members into the business and reduce the taxes that would ultimately be payable over the long run and on a year-by-year basis. At this point, I would like to take the opportunity to introduce the members of our expert panel. The first individual I would like to introduce you to is Lorne Saltman. In addition to Lorne's primary role as head of the tax department for the law firm Gardiner Roberts, Lorne is also a partner in Forvest Family Offices. He is also counsel to Quantum Tax Law. Lorne has significant experience in corporate reorganizations, tax disputes, dealing with mergers and acquisitions, setting up preservation methodologies for high net worth individuals, including real estate ventures and other trusts and foundations. Lorne has lectured extensively to the Ontario Bar Association, the Canadian Bar Association, the American Bar Association, and the International Bar Association. Lorne is indeed recognized in Canada and outside of our borders as one of the leading experts in Canada in the area of taxation. I would also like to introduce Brian Carr, who is with us. And Brian was the former chair of the Canadian Tax Foundation, past chair of the National Taxation Law Section of the Canadian Bar Association. Brian is currently the co-chairman for the Canadian Bar Association Program Tax Law for Lawyers. He's very much involved in education. Brian has received too many accolades to mention. He's a noted author where he's received awards for that. Plus, he's also received the Queen Elizabeth II Diamond Jubilee Medal for his service to the Canadian Tax Foundation. Brian has also received an Award of Excellence from the Canadian Bar Association and a Lifetime Achievement Award by the Canadian Tax Foundation. Also, last but not least, I would like to introduce John McLeod. John had started his career many years ago in the banking industry. He's worked for the Royal Bank, where he was a senior executive in charge of fiduciary services. And since then, John has been working for the international group Eticas and Forvest Family Offices, who located in countries like Singapore, places like Singapore, Geneva, and of course, John is living in Barbados. John also is noted internationally for the work that he does in fiduciary services. My name is Todd Louie. I'm a partner in quantum tax law. I'm involved quite extensively in tax dispute issues. I'm also very much involved in corporate reorganizations, including the use of trusts. Also involved with estate freezes and butterfly transactions and a number of different type of tax strategies that may be of some value during today's program. To that end, I would like to draw your attention to a slide. If Jeremy, if you could please make the presentation available to me for a moment. As Jeremy activates the program, I'm going to talk a little bit about some of the problems that we perceive. One of the first subjects we're intending to talk about is how we can take advantage of opportunities in a depressed economy, and how an economic crisis does have a silver lining, how there is opportunities for your clients, if you're a lawyer or accountant, or if you're a business owner, how there's opportunity for you to save a significant amount of money in tax by organizing your affairs properly. One of the issues that we'd like to talk about in order to get this started is asset protection. And of course, many of you who have corporations are done planning in order to protect your assets, either through the provision of limited liability that will be afforded to you through your corporation, or through the use of trusts and other kinds of planning. One of the subjects we discussed in our first in the series last week was the fact that it is a very difficult goal to achieve in Canada. In effect, we had made the point that Canada, regrettably, has become a creditor-friendly country. And we say that because Canada has provincial legislation in all provinces, which is known as the Fraudulent Conveyances Act. The Fraudulent Conveyances Act essentially says, if you're attempting to hinder, to delay, or defraud a creditor, then a creditor can ask for a special award that can seize assets, even though you've moved them to other corporations. Supposing you've set up an operating company and a holding company, and you've decided to move that money up. Well, the Fraudulent Conveyances Act that we have in Canada has become far more burdensome, far more onerous for wealthy families in Canada. To the extent that it's become a greater concern, was exacerbated by the fact that there was a change in the legislation in 2012, which I believe our panelists are concerned about. And to the extent we're concerned, it's justified based on the fact that the wording had changed. Prior to 2012, the Fraudulent Conveyances Act essentially would have meant that one would have had to commit a dishonest deed. Now, since 2012, the Fraudulent Conveyances Act has been amended. It received royal dissent in order to change the terms to hinder, delay, defraud, in contrast to the prior wording, which included words like guile and malice, which are no longer required. In order to quote the Chief Justice of the Federal Court of Appeal, Chief Justice Finch mentioned that there's no longer a requirement for dishonesty, only an attempt to move assets and having the result hindering the collection of these assets. So therefore, we're suggesting that there's more reasons than ever, if it's true, that there's going to be widespread insolvencies. If it's so, that there's going to be bankruptcies, then what better time is there than now to consider how to protect your clients, if you're a business owner, how to protect your assets. And once you have a creditor at the door, once your own clients aren't paying you, once you're in a situation where you're not able to necessarily service your debt obligations through the regular cash flow of the company, well, it's too late to start saying we're going to move assets. So that's kind of the preface for our conversation today. At this point, I would like to draw your attention to the whole issue. And this became evident to us some time ago. Myself and Lorne Saltman, who's in attendance, the former Chief Justice of the Tax Court of Canada, the Honorable Donald G.H. Bowman, served on a panel. Yeah. And the panel was made up. Sorry, I think somebody's cutting in on our line here. I'm not sure. The panel that was established was set up for the purposes of addressing estate lawyers. And through this process, over the last few years, we've realized that there's issues with professionals operating in silos. We were speaking to a group of estate lawyers who were asked, what are they doing to provide for the most efficient way to transfer assets to the next generation? And one of the things that came to mind is it isn't always the case that estate lawyers are necessarily looking at some of the finer tax issues. And of course, that's a general statement. Oftentimes, they're leaving it to the accountant, and that was one of the comments. So I asked the question to the lawyers in the Canadian Bar Association, what are you doing to look under the shares? How are you looking under the shares? And I had one very bewildered member of the audience said, what does that mean? And I said, well, are you considering non-active assets? Are you considering how you're going to achieve tax advantages when you have real estate, stock portfolios, life insurance, and other things inside of a company? And he said, well, we leave those issues to the accountants. There's a tremendous loss of tax benefits if you don't separate the assets. If you're able to separate your active assets on the left part of your screen from the non-active assets on the right, it provides eligibility for, in some cases, multiple capital gains exemptions that wouldn't be available because of the presence of all of these assets. The legislature intended that companies who qualify for the capital gains exemption, which is $866,000 per person, not hoard cash inside their company. Therefore, even cash is considered a non-active asset that can constitute the loss. The other problem is if you have a risky business or you're in a litigious business, let's put it that way, then you might be concerned about having the assets inside of the company. In the event you're sued, well, you'd lose the assets. So in order to resolve these problems, we have heard from accountants and lawyers as far as what they're doing. And here is what might be a bright idea. And what I'd like to do is pose this question to the audience. We have a company who's in a litigious business that we're calling Risco. They were concerned about lawsuits in the past because they were doing installations, say, of boilers that were outdated, which presented certain fire hazards and other problems. And they decided to move their clients over to a newly formed corporation called Safeco because they were trying to safeguard their business. And therefore, if someone sued Risco because of an installation that happened, say, 20 years ago, well, then the idea is they'd still have their business because all of their clients have been moved over and therefore would be out of the reach of creditors. And we've seen this strategy employed over and over in our various different visits we've made and lectures we've done in Vancouver, Calgary, Edmonton, Toronto, and other places. So at this point, I'd like to turn the question over to the panelists, whether or not this concept of migrating clients or moving clients over in order to protect the efficacy of your business or the solvency of your business in case of a prior lawsuit would make any sense. Perhaps I'd call on Lorne Saltman, please, just to comment on this strategy and what your view would be from a tax perspective.
Sure. Thanks, Todd. If we look at what the facts that Todd has presented include client names and lists and so on, it's not often recognized that that constitutes an asset of the transferor company that has significant value. And because the diagram you see the same shareholder owns both the transferor and the transferee, these are parties that are dealing not at arm's length under the Income Tax Act, and for purposes of the Fraudulent Conveyances Act that Todd alluded to earlier, there's a commercial risk. So we've got a tax risk and a commercial risk. The tax one is that on the transfer of the valuable assets, the transferor will be deemed to have realized fair market value proceeds, triggering tax on income and capital gains. That has to be done at fair market value, or alternatively under the available rollover rules, such as subsection 85(1), taking back shares in the transferee company. But of course, that doesn't insulate assets of the RISCO. What you're doing is deferring tax, but still continuing to have exposure. And the other tax element to this that's important is, let's say that the transfers were done and the Canada Revenue Agency comes along looking at the debtor corporation, the transferor, and is able to, under the Income Tax Act, a special rule permitting it to follow the asset into the transferee company. And because the transfer was done for less than fair market value, assess the transferee company for the unpaid tax, interest, and impose any penalties that might have applied to the transferor company. So we've got some significant tax issues arising from what might appear to be a simple transaction, transferring those customer lists. And on the fraudulent conveyances side, if the purpose of that transfer was to hinder, delay, or defraud creditors, there's the commercial risk that a court would set aside the transfer and put the assets back into the transferor away from the transferee. There we go.
Thank you. Thank you, Lorne. Brian, I was just curious on your view as a litigator, known as litigating many cases in Canada. How do you think the courts would view a situation where a business owner unknowingly transferred clients to a new corporation without reporting a gain? What kind of chance do you think they'd have of being successful? Oh, you have to unmute yourself, Brian. Yeah. Now, Jeremy, can you unmute Brian?
Okay. All right. I'm good to go.
Good. You're good to go, please.
Okay. I mean, I don't, based on the very sparse facts that we have before us, I don't think the taxpayer would be very successful before court. There's not much of an argument that the transferor corporation has taken back any kind of consideration. One would obviously look at the value of what's being transferred across. In this particular situation, we didn't report anything. Not only have the tax to pay, but you probably have some penalties under one of the sections for not reporting the income. So it's a double whammy. And it's also the under Section 160, the transferee corporation would also be liable for any tax that the transferor didn't pay. So it would not be a happy situation ultimately for the taxpayer.
Well, thank you, Brian. John, I'd like to call on you just for a moment, and eventually we're going to be talking about use of trusts. For the time being, perhaps you could comment upon the differences that an investor would face, or a business owner would face, say having assets in Canada versus other jurisdictions, say where you live in Barbados, as an example, as a result of not having a fraudulent conveyances.
Sure. I think that as you mentioned earlier, Todd, Canada has become a creditor-friendly country. And so internationally, we've seen an explosion in the number of trusts that have been created in order to to facilitate intergenerational transfer and asset protection. Now, when a Canadian settles a trust for the benefit of themselves and their family and so on, the non-resident trust rules in Canada would say that the trust is deemed to be taxable trust in Canada. And therefore, there's not a significant difference in the taxation, although a little later in the program, we'll talk about some unique techniques that Lorne will address that will talk about how to get a bit of tax advantage as well. So people are moving to asset protection jurisdictions primarily for asset protection and intergenerational estate planning purposes to give certainty of outcome. And they don't want any creditor in that case, whether it be a spouse, a family member, a trade creditor, a tax authority, or anybody else, to have a successful claim, as long as they've met all of the necessary requirements for asset protection, which are, number one, you must be solvent at the time of the transfer. So now would be the time to do a transfer. Number two, the transfer can't render you insolvent, which it generally doesn't, particularly if you're conveying, shares in a company, which tend to be people's largest assets, business owners' largest assets. Number three, the trust property can't be the proceeds of crime, and generally when you're transferring shares in your operating company, they're not the proceeds of crime. And finally, the transfer can't be a fraudulent conveyance. Now, in the international jurisdiction, fraudulent conveyance would apply only to an existing and known creditor, unlike Canada, which says any creditor now or at any time in the future. And that's why we've seen such an uptake in international structures over domestic Canadian structures.
Thank you, John. Jeremy, if we could have the next slide, please. 2 more slides forward. So essentially, 1 more slide, please. The next one. The other issue we've seen, no, go back 1, please. The other issue that we see often, and not so long ago, we were doing a lecture for an accounting group, and we asked them what they're doing to create asset protection. And one accountant put up his hand. He said, well, that's easy. The best thing to do is to set up a holding company on top of your operating company and to pay up a dividend. And we pay large dividends. He cited dividends in excess of $1 million that are being paid quite routinely. And what oftentimes gets overlooked is the fact that paying excessive dividends can present tax problems. Not only that, but they can fail to achieve the purpose in which the taxpayers intended by simply moving money from an operating company up into a holding company. Lorne, I'd like for you to elaborate, please, on the tax consequences that may be possible in this scenario.
Sure. As Todd has said, typically it's been the practice simply to pay dividends between a sub and a parent domestically that should be tax-free. But back in, I think, about 2016 or so, 2017, the government became concerned that such dividends may unduly reduce capital gains on future sale. And so now we have to be very careful and make sure that we have enough safe income in the sub. And if we are paying a dividend up to the parent in excess of that safe income, we could have the dividend recharacterized as a capital gain instead of it being tax-free. And just very briefly, safe income is a concept that takes into account after-tax income earned in the subsidiary since 1971. And so whenever now we're looking at paying a dividend from a sub to a parent, there has to be a calculation of what safe income on hand exists, or we could face the recharacterization if the of the dividend as a capital gain if the purpose was to reduce a capital gain or increase the cost base of the shares the parent has in the sub. And so even A classic domestic arrangement that one thinks is very benign has risks inherent with it, and not to ignore the commercial risks. If the purpose of the dividend being paid to a related party can be viewed under the Fraudulent Conveyances Act as intended to hinder, delay, or defraud creditors, that's another point of attack that can be used to put the asset back into the subsidiary company for the purpose of the creditors.
Thank you, Lorne. I think what we'd like you to understand is that it's a question of awareness. We're not suggesting that you cannot pay large dividends any longer from the operating company to the holding company, but it would be entirely imprudent to arbitrarily pay dividends, excessive amounts from an operating company to a holding company without first considering the purpose test that's come into existence in 2016 in a new form that now results in very punitive results. The results would be that the dividend gets converted into a taxable capital gain. Brian, I'd like to call on you to address the audience as far as how the courts we realize there hasn't been any court cases on this since this whole issue of purpose test is rather new, but we'd like to hear your point of view on the way that the courts would likely look at this.
Well, as you put your finger on the real problem is we've not had any litigation that we can look at. The section as drafted has been strongly criticized by most practitioners in the area as being unworkable. There are a couple of purpose tests in the legislation. One would hope that in most situations the court would come to a conclusion that the taxpayer hasn't, I guess, breached the purpose test, that the purpose was not to reduce the capital gain. I think in practice, the court will be influenced by subsequent facts. Obviously, what CRA was trying to get at were transactions like this, subsequent sales, where there are no subsequent sales and where there is strong evidence that what was being done primarily for asset protection. I think the court will not apply the section. That's sort of my view. And as I say, a lot will be I know I'm sounding like CRA right now, but a lot of it will depend upon the actual facts that are in existence that the taxpayer has to deal with. I'm just as an aside, the more litigation I do, the more I realize that facts are key to everything. You just have to understand all the facts in a particular situation before you can really come to a conclusion. So again, we depend upon the facts, but I suspect in most situations, the CRA would be unsuccessful in their run at you. But there are risks.
Thank you, Brian. Needless to say, for all in attendance, accountants, lawyers, business owners, be very cautious. Please don't be migrating clients without giving consideration that you might be triggering a taxable event. Please don't be doing what we're talking about here. Instead, let us talk about a strategy in the next slide that may be more prudent. Now, I recall attending a lecture on this next slide. Jeremy, if you'd advance the slide, please. This is a way that you can essentially move assets from one corporation to another. This is, for those of you who are accountants and lawyers, you possibly have been involved in a Section 55(3)(a) butterfly. We call it a butterfly because the effect of moving assets from Risco to NewCo involve a series of transactions that in some ways resemble the wings of a butterfly. In this case, a single wing butterfly that would be involved with issuing new shares that have a specific redemption value, that have no tax cost, issuing them over to the newly formed company, redeeming the shares back, and paying over the cash or other investments without triggering any tax whatsoever. And to most, they consider this exotic. But this is a solution that we'd like to suggest that you might want to consider. Lorne, I'd like to maybe ask you to comment on the instances where it would be prudent for a business owner, for an accountant or lawyer to consider a single wing butterfly in order to properly move assets without worrying about some of the things we've discussed.
Sure. It's called a corporate purification because one of the purposes of analysis in the risk co that Todd has alluded to earlier is to understand what assets are critical to carrying on the active business and what assets are investments or redundant assets. If we're thinking eventually about the shareholder disposing of his or her shares either by way of death, sale, or departure from Canada, we have actual or deemed dispositions. There's going to be a capital gain. And if we can make sure that the shares owned by the shareholder are qualified small business corporation shares, we can get the capital gains exemption of some $860,000 per individual. Later, we'll talk about estate planning, where we have the potential for multiplying that lifetime capital gains exemption within the family through the use of a trust. But right now, the focus is on purifying the company that eventually will be disposed of so that the exemption would be available. And by doing this non-arm's length transfer using subsection 85(1) and the elective provisions to defer on a rollover basis the shares and assets that Todd has described, we're able to avoid the problem we talked about in the first slide, which was the transfer of the valuable client lists for nominal consideration and triggering an immediate gain. Here we're doing it on a fully compliant basis within the controlled group because the shareholder is both the owner of the transferor and the transferee, but we're doing it on a compliant basis. So we are purifying the operating company. We are putting the investment assets into a separate company, and when the transferor company is ultimately sold, if we've complied with all the proper rules, the lifetime capital gains exemption would now be available to us.
Very good, very good. So really there's a couple of things. The first issue that we had talked about previously being the Fraudulent Conveyances Act would have no bearing on this, by the way. That's one thing I'd like to make a point of. We're really talking about the capability to be able to separate assets. Brian, you authored a publication called The Modern Butterfly. And I think arguably you're one of the best known experts in Canada on butterfly transactions. What would you say about the efficacy of this kind of a process? Even though it's not common, what would your comment be on utilization?
Well, I guess I would say it's fairly standard and well understood, and it's certainly not an aggressive tax planning at all. It's well accepted by the CRA, who has given numerous rulings. You have to follow the rules. You have to be careful about your fair market value that is properly determined. You get back shares inconsistent with that. There are a number of other criteria that require that arm's length people don't acquire interests in the companies as part of the same series of transactions. So that's something that the section, we probably simplified it quite a bit for people, but the section is quite, like a lot of sections in the Act is long and tedious and sets us a number of criteria, but as long as you follow them, you will be fine. And this is standard practice that's accepted by the CRA.
Very good. Thank you very much. If we could have the next slide, please, Jeremy. So here we're essentially talking about how an estate freeze works. And I think that rather than belaboring how an estate freeze works, we're going to talk about the result. Can we just maybe bypass that slide? We'll go to the next one. So here we have another situation, and I'm going to pose this question to the audience. And this was performed by a law firm in conjunction with an accounting firm. And we were called in to do an analysis afterward. And this is one of the things we found. And we pointed out to the firms that requested our suggestion. In this particular case, an estate freeze was performed, which involved the shareholder of the company being a family business, and the father had exchanged his common shares, which grow in value. He exchanged them for preferred shares, which stay the same value. resulting in a capping, a freezing, or a limiting of the value of the shares that the entrepreneur owned. And in turn, the law firm and the accounting firm got together. They figured out the values, they attributed the values to the shares. Then they issued new common shares to a family trust. And the new family shares, the new common shares that were issued to the trust were then issued to the trust, and the trust in turn was established in such a way that it had the Safeco off to the right. This means that they created essentially a flow through where they were able to move $1 million in cash. Well, we've talked already about the question of whether you should be paying excessive dividends on the shares of the RISCO or the operating company or not. Well, the same applies in this case to the trust. That same question persists. But we have another issue. After the estate freeze, we determined that the company still had $5 million of redundant cash in the company. Total assets, including goodwill of the company, was no more than, say, 20 million. I would like the audience to consider whether or not the accounting firm and the law firm had considered all of the different issues before implementing the estate freeze on behalf of this particular taxpayer. And while you're doing that, I'd like to call on Lorne Saltman to comment on the efficacy of this plan in light of the fact that money's been left behind.
Sure. Going back to what I was talking about earlier for the lifetime capital gains exemption, the shares of a RISCO have to meet the test of qualified small business corporation shares. And without going into all the technicalities, one of the key features is we have to look at where does the fair market value of the shares derive from looking at the active business and the assets of RISCO. If more than 10% of the assets are from redundant, if more than 10% of the value of the shares is derived from redundant assets, such as this excess cash in RISCO, we have missed what's called the 90% test at the time of disposition, and we will not qualify for the lifetime capital gains exemption. So what we have to do when we're doing an estate freeze is purify in this case, RISCO, so that it is now meeting the test if it's a single operating company for the 24-month period. More than 50% of the fair market value of the shares would be derived from assets used in conducting an active business. And again, at the time of disposition, we have to meet the 90% test. And there are more complications if we have holding companies, which we won't get into in this discussion, but the principle is the same. We have to very carefully, in an estate freeze, make sure that the operating company's shares meet the test of qualified small business corporation shares at the time we are purifying and are able to maintain the status as we go forward. That's all.
On the note of estate freezes, we find that many times business owners receive advice as to when is the best time to do an estate freeze, or at what value should an estate freeze be performed. I'd just be curious, Lorne, maybe if you could just give your view of the best timing to do an estate freeze, providing a company is successful and growing in a predictable fashion.
There's a balance that has to be viewed and maintained as to what are the goals that the entrepreneur and his family have, short-term, long-term, are there succession plans, etc. Some people are of the view that you don't do an estate freeze until the 50s, 60s, 70s, because they don't want to lose control over the business. Others are concerned about doing an estate freeze at all, where so much control is shifted from the older generation to the next that the older generation has insufficient assets and has to turn to their children and grandchildren, which nobody wants to have to do. So each situation has to be looked at and a customized approach taken. But my preference is to put forward before clients, do it earlier rather than later, but do it in such a way that you maintain the control that you want and that we have a transition plan for succession that preserves sufficient assets for you, the senior generation, but gives operating responsibilities and gradually operating control to the next generation. Just to give one very brief, quick example, a number of years ago, there were several investment bankers in a large bank who were unhappy with staying in the bank. So they decided they would form a new organization, and they did. The particular organization contemplated a partnership of several partners, but what they did was each partner set up a company that invested in the partnership. And we did an estate freeze for each of the companies right off the bat, right when they left the bank and set up their own structure. So we had the investment banker voting, controlling shares of the company, and a family trust owning the common shares of the company. And the view of the group was that they would like to carry on this new business for, let's say, 5 to 10 years, and then if things went well, they would go public or maybe be bought out by another financial institution. Well, 5 years later, indeed, they were bought out by a large financial institution. And between the beginning and the 5-year period, there was significant growth in the value of common shares owned by the trust in each of these, what we called capital corporations. And one family in particular had in their trust several family members, husband, wife, and 4 children. They had 6 lifetime capital gains exemptions available to them. And all that was successfully done because they set up the estate freeze right at the beginning of the business. They maintained control and they were able to take advantage of the opportunities when they presented themselves several years later.
Very good, very good. So there's the answer to the question.
I had one situation in which a prominent family did some estate planning in the 50s and 60s, and were very successful in the estate planning and managed to avoid succession duties and on one death, and managed to avoid capital gains on another death, and didn't end up paying any tax until it ran out of the 21-year rule sometime in the late 90s. So it was a very successful plan that avoided taxes for up to 40 years. So it can be, some of these can be very successful. I guess the pitfalls are situations in which you plan to have the children and grandchildren take over a business and find out that the grandchildren don't quite match up to what you want. They're not the people who can manage things at all. So somehow you have to find a way of building flexibility into these situations so that you can reverse some of the planning if necessary.
Thank you, Brian. John, I'd like to maybe just call on you, if you wouldn't mind, just to provide a definition for those in attendance about what a trust is. Perhaps you could give a brief background and describe how a trust is used in the context of an estate freeze.
Sure. A trust is a well-known, well-recognized concept in common law that's been around since the 11th century. So there's an abundance of case law in every common law jurisdiction. And I might add now accepted into civil law jurisdictions. And in fact, some people say that the civil law jurisdictions are the fastest growing trust jurisdictions in the world. However, a trust at its core is a relationship between a settlor or a person with assets who wants to transfer those assets to the trustee, who becomes the owner of record, for the benefit of a group of people called the trustee, or called the beneficiaries. And typically, in all of the examples that we've just talked about, the settlor might be the business owner. The trustee could either be a domestic trustee or an international trustee, such as the Eticas group that I represent, or others. And the beneficiaries would normally include the settlor and the settlor's spouse and children and grandchildren and so on.
Well, thank you very much, John. Jeremy, if we could move on to the next slide, please. So here we have another situation. We see this often, interestingly enough. We have a situation where there are two individuals who each own 50% of an operating company to the left on the before diagram. And as it turned out, the accountants and lawyers made some suggestions on how business owners could best structure their affairs to introduce family members as shareholders. Mr. Jones and Mr. Smith had reached retirement age, and it was recommended to the business owners that Mr. Smith, as in the right diagram, decides to transfer his shares to Mr. Jones' company for $1. Mr. Jones decided to sell his shares to Mr. Smith's company for proceeds equal to $1. And the reason that it was suggested is because Section 69 of the Income Tax Act provides that where there is a transfer of shares to individuals who are related, who are not at arm's length, then the tax ought to be calculated on fair market value of that asset. And since Mr. Jones is not related to Mr. Smith, and Mr. Smith not related to Mr. Jones, the advice they received was to transfer the assets to each other's holding company. And we've seen this often, these sorts of approaches. And I suppose before we go further, maybe I'd like to call on Brian first to give his comment on what the issue is and perhaps how the courts would view it.
Well, I don't think they've got much of a chance of succeeding on this one. Even though they're technically not, even though technically they may be at arm's length, they are not at arm's length in fact. So they're just each other's accommodation party. So the transfer by Mr. Smith to Mr. Jones's company, and transfer by Mr. Jones of his shares to Mr. Smith, would be treated as being disposed of at fair market value for purposes of the Act.
Brian, I'm just curious, of whether or not you can think of any matters in the past where you've had issues such as the disposition of shares to individuals that are deemed to be related, and if there's any experience you might be able to share in reference to the way that the courts would typically look at these things.
Well, you usually have a little more complicated arrangements in this. You've got the factual situation you've presented is kind of pretty blatant. You can have a much more complicated situations in which it's far from clear that the people are non-arm's length with one another in the corporate world. Frequently you have corporations where you have interlocking boards and so on, and it's not at all clear that those corporations are factually arm's length with one another.
Lorne, I'd like to ask your view of this. Say that the proceeds for the sale was $1. You believe that there would be any significance as to whether or not this Mr. Jones or Mr. Smith, respectively, would be prepared to sell their shares for $1 to a total stranger?
Clearly not. It immediately will be a red flag for a CRA auditor if that's done. The CRA will look at the operating company where you've got two equal shareholders, and they will presume, and they've said in their bulletins, they will presume that the two may be acting in concert, is the way the jurisprudence has described what, in fact, a situation where parties are in fact dealing not at arm's length when they appear to be at arm's length. So if we start with that presumption, we have to think about, well, how can a transfer at less than fair market value rebut that presumption? It doesn't. It actually reinforces that presumption. So when we're thinking about transfers, what we need to think about is what's the existing situation? How's it being documented? Is it going to be compliant? What has the CRA said, and the courts? What have the courts said about these kinds of transactions, and how do we make sure that we limit our risk when we're doing that?
Where we believe that we might, something we've done might be later called into question. I'd like to ask Brian about your view of the type of evidence that one should keep if, in fact, optically things may appear in a way that they may not have been. And Brian, I'm just curious from the point of view of a litigator, what would your opinion be?
Well, you'd want, first of all, some memoranda around some hard documents that state what people are doing and why they're doing it. Some of them may be self-serving, but at least they're a starting point. You want the people who are doing the planning to understand the planning so that if there's ever a dispute with the CRA, they can testify as to what their intention was. There was a case a few months ago in the courts where there was an anti-avoidance section issue, and it's always hard to know when someone's presented a case why it went the way it did, but for whatever reason, the counsel for the taxpayers was not able to put on the stand the principal taxpayers who were involved in the transaction, which drew a negative inference from the judge. There was absolutely no contemporaneous documentation that counsel could present to the court that supported their position as to why they did the transaction. And the court really, at the end of the day, had absolutely no alternative but to accept the Crown's position that this was done solely for tax reasons, and that they had run afoul of one of the anti-avoidance provisions. So yes, memoranda, letters, correspondence, what have you, recitals and documents are helpful, and making sure that the people that are involved most intimately really understand what's happening, so that they can say in court what they did.
And Lorne, what would your view be of, say, attribution rules applying to a situation like this, where benefits or rather interest is received by individuals other than the original operating company? What would your comment be on the possibility of, say, a 74.4 spousal issues or minor children? In this case, it'd be no minor children because we have direct shareholders. But do you see that there might be some risk there?
What Todd is referring to are a set of very onerous rules we call the Attribution Rules. And here the government has over the years been concerned that high-rate taxpayers are trying to shift the generation of income, either by way of payments being made or assets being transferred that can generate dividends or other forms of income, shift them from a high-rate family member to a low tax rate family member, or a corporation of which other family members are shareholders. And in particular, there's a corporate attribution rule that we have to be concerned about in every estate freeze, where an entrepreneur, let's say, does an exchange of common shares for fixed value shares equal to the fair market value of the common shares today, and a trust acquires nominal value common shares for the benefit, let's say, of spouse and children. That could give rise to the corporate attribution rule, which would deem the preferred shares now that the entrepreneur has taken back to be debt, and prescribed interest would be required to be included in the income of the entrepreneur. Instead of it being tax-free, it's generating annual income tax. And what we have to be very careful of is whether this structure was set up for the purpose of transferring or shifting income from the high rate to the low rate tax. And typically what we do in those situations is we try to exclude a spouse from the trust, and we exclude any child or grandchild, niece or nephew who is under 18 years of age. Those are all called designated persons. Once a child reaches the age of 18, he or she is no longer a designated person, so they can benefit from the trust. But the idea is that the trust owns common growth shares, and there won't be distributions to minor children that could give rise to the attribution rules, not until a child reaches the age of 18. So these are a set of minefields that we have to be very careful of when we're doing any of these estate plans.
Very good. Jeremy, can we have the next slide, please? Here's another situation where the accountants and advisors of this particular company had suggested that there was no need to do an estate freeze because they were too young. The individuals are in their 50s. They were advised that it would be best that they come back and look at doing an estate freeze, you know, say 5 or 10 years from now, when they were in a position where they'd be most likely not to require assets of the company. One of the key components of a properly architected plan that provides for an estate freeze is ensuring that the shareholders retain control of the company. Even if they decide to redeem shares for purposes of withdrawing cash from the company, they still maintain control. So a properly structured trust can mean that there's no need to wait. Meanwhile, what ended up happening with this company is they had established a second operating company to the bottom of the screen in the US that we're calling OpCo USA. And then you'll note that in the two holding companies, the shareholders on both the left and right side at the top both have over $1 million of cash inside of the holding companies. And they have life insurance policies that have cash surrender value, which would mean that this company would have an abundance of these non-active assets. And to give background to what we're talking about, there's been two court cases. One is a Tax Court of Canada decision. The other is a Supreme Court of Canada decision. Both of them essentially say the same thing. And that is, when determining whether assets are considered active or non-active, the one case, Tax Court of Canada decision states that the assets would have to, the withdrawal of the assets would have to have a decidedly destabilizing effect on the company. And when we think of $1 million of cash that's parked in GICs or in a bank account in the holding company, it would be very difficult for us to argue that if that money was withdrawn out of the holding company, it would have a decidedly destabilizing effect on the OpCo. The other problem that we perceive is that the assets should be domestic. Oftentimes, when individuals add another corporation, unfortunately, because professionals work in silos, we talked about estate lawyers, we talked about corporate lawyers, we talk about accountants, many of these very important tax issues are not necessarily considered in all cases. In this particular instance, the assets under the operating company, in order for the shares to be eligible for the capital gains exemption, not only should be active, but they should be domestic Canadian assets, not the shares of a US corporation. The other issue that we have is a real estate company, which holds a building that's worth about $5 million, which the operating company does occupy, and there are no tenants. At this point, maybe I'll turn this over to Lorne to comment on, and this is not uncommon. We see this in every province in Canada. And we know that we have individuals from all across Canada in the program, and this is by no means unique. But Lorne, perhaps you might want to comment on the implications of this kind of planning and this kind of structure.
So I'll just focus on the relationship between OpCo and RealCo. You've touched on the rest of it, Todd. If OpCo has made a loan to RealCo. It has an asset, a loan receivable, and that is an investment that, again, is not going to be eligible for the active business asset test that we talked about earlier in respect of the shares of OpCo. We would have to meet that 90% test. And so part of purification exercise will be to transfer these assets, the loans receivable, out of the OpCo to other companies that are not going to be involved in owning shares that or issuing shares that are going to give rise to the eligibility for the lifetime capital gains exemption. So overall, what this illustration shows is each company has to be analyzed on its own to see where it fits in, what its asset mix is, and if there could be a tainting of the qualification for the lifetime capital gains exemption. We need to go through a very careful purification transaction to create the right kind of structure.
Thank you, Lorne. Brian, I was curious on your comments of, how the courts, may want to consider the characterization of active assets in light of the cases I referred to. I was referring to Riley versus Her Majesty the Queen. I was referring to, well, actually 2 cases I was referring to, but I'll leave that up to you. I'll have you comment on the way that the courts might characterize, investments or life insurance that's not used for collateral or for cash investments, things like that. You need to be unmuted, Brian. No, still not working.
Now I am. Okay.
There you go.
Okay. There's a couple of fairly famous cases called Insight and Johns Manville back in the late 70s involving active business income. The courts actually have been fairly generous with what they mean by active business income. And that's one of the reasons why we have such extensive FAPI provisions. There was a case involving Canada Trust Co. I think it was not the famous Canada Trust Co. one, but another Canada Trust case in 1993, in which an offshore company held a portfolio of mortgages, and the CRA said that was passive income, and the Canada Trust Co. argued no. Managing a portfolio of mortgages was in fact active business income, and the court accepted that. And sometimes you win the battle but lose the war with the Department of Finance. So that was the beginning of the I wouldn't say the beginning of the complex rules, because the FAPI rules have always been complex, but they added several more layers of complexity to those rules as a result of that decision. So by and large, the courts have been fairly helpful in terms of finding that assets are active business. Now, I think the Insight case involved a situation where they were trying to argue that income in a foreign country was active business, and they wanted to get the integration. And the question, the criteria the court used was, in that particular case, whether removal of the assets would destabilize the business of the corporation. If that were the case, then they were not redundant assets and were clearly part of the active business income.
Yeah, very good, very good. Thank you. So, needless to say, what we see as attempts to do proper tax planning is all with the best intention. But there's also an expression that the road to hell is paved with good intention. So I believe that it's important enough to consider some of these important variables when doing the planning. Jeremy, can we look at the next slide, please? So here we have the same structure that we just talked about that resolves problems in a certain way. And here we have a situation where the shareholders of these companies, I'm talking about the holding companies, would then elect to exchange their common shares for preferred shares and have the common shares go to a trust. And the trust in turn would hold shares of an investment company. And perhaps I'd call on John McLeod to talk about the type of assets that trusts hold and where a trust holds shares of a corporation, how that plays into the tax planning. And then we'll discuss further on what some of the issues here could be done to remedy some of the problems at least.
Well, Todd, let me begin by saying that as we discussed earlier, asset protection, both in this lifetime and in future generations, tends to be a tremendous driver for individuals setting up trusts, Canadians in particular. Canadians generally try and put their most valuable assets into trust. In the case of entrepreneurs, it's generally shares in their operating companies. As Lorne mentioned earlier, if an estate freeze is done and common shares are transferred to the trust, that allows for several tremendous advantages. Number one, all the future growth gets kicked out for a generation for income tax purposes. Number two, there's greater asset protection. Number three, there's the capturing of multiple capital gains tax exemptions. So the drivers up until 2 months ago were conventional estate planning and continue to be. But now there's an overlay of concern at the asset protection level. And when you talked about doing an estate freeze and the timing of it, there is a school of thought shared by many practitioners in Canada today that this may be today, now, the best time in any of our lifetimes in which to A, do an estate freeze, or B, transfer assets into a trust. Whether it's an investment portfolio, which is the most substantial family asset, or family active business or holding companies, in most cases, there will have been a significant decrease in value, particularly in the last few months. In the case of companies that hold investment portfolios, the value of that company may have decreased by over 30%. And therefore, any deemed disposition tax that would apply would be reduced by over 30%. Also, in talking to business valuators, most Canadian businesses, even those that have not been substantially thus far affected by the COVID crisis, can now substantiate significantly lower values than they would have 2 or 3 months ago because of a pantheon of risks that now exist, including the suppliers to those companies' ability to pay, insolvencies in and downstream companies and suppliers and customers. So with regard to the types of assets, it's unlimited. We are even seeing people with significant commercial real estate portfolios. I'm thinking about, in one case, downtown Toronto real estate, where the owner in question is saying, you know what, now that everybody in the country is working at home, CFOs are coming to the decision that maybe we don't have to invest as much in bricks and mortar in downtown locations. If we can operate our business at a lower cost, more remotely, and not require our employees to live in large, expensive urban centers and maintain property. So even the real estate business is showing some signs of decrease in value, which supports everything that Lorne and Brian and you have said about there has not been in our lifetimes a better time to consider doing estate freezes, doing estate plans, and bulletproofing your corporate and personal assets.
Well, thank you very much for that, John. And just to kind of take a step back as to the reason we're assembling at this time is because of the fact that opportunities do exist. And on a very practical level, we had in our last session last Thursday, and by the way, this session is being repeated every Thursday at 1 o'clock. And we're very happy to be able to take feedback, and we're asking you for feedback on the kinds of subjects you'd like to know about. Last week, we had two prominent business valuators who both gave their view. One of the individuals said that a company that he would have looked at buying a month ago would have a value of less than 50% by today's standards. If you were a shareholder of that company, it's not that you would entertain selling. This is not a time to sell unless you need to. There are three liquidation events that we will talk about just briefly. One is the selling of the shares. Two is the death. And third is departure from Canada. All of those things constitute a taxable event. In the event that you're able to freeze the value of your company, like John was alluding to, at a much, much lower perceived value today, the result could be millions of dollars in savings to you and your family, either through the sale of the shares where there's multiple capital gains exemptions that are taken advantage of, or perhaps if it happens to be that it's more of an estate planning issue to mitigate or reduce the taxes on death. In this particular situation, we were able to suggest how these shareholders are able to butterfly money from the holding companies over to the investment companies. We talked about butterflies before, and in reality, there wasn't a solution available to this company or to their advisors without doing something that was considered exotic. What does that mean? I mean, there isn't many things that we're born knowing how to do other than the fundamental things that keep us alive. Therefore, when there are things that are different, it doesn't make them unreachable. It doesn't make them impractical. We're talking about some very important issues that means doing it right. And to that note, on that, Jeremy, would you move to the next slide, please? So just a couple of examples of some of the things that can be done. We talk about a butterfly transaction. We see a lot of professional corporations. And I noticed that there was some doctors and dentists that have joined us today. And we appreciate that given the regulations that govern your associations, it means that you usually can't have non-licensed individuals as shareholders. This is a particular situation where we've been able to help individuals in this situation because dentists who are able to sell their practices often lose a capital gains exemption because they build up excessive amounts of cash. Through this sort of transaction, and without going into an enormous amount of detail, we're able to purify a professional corporation and create a conduit that will allow for and provide for the transfer of cash on an annual basis up to a corporation whereby there is no need for a capital gains exemption. In this particular case, the conduit or the stream that goes upward into the investment company goes to a place where you can accumulate redundant assets. To your right side, you've got non-active assets. To the left side, you have active assets, resulting in a tax savings of, say, $220,000 for this dentist. Jeremy, can we go on to the next slide? Lorne, we've been talking a lot about tax planning. We've been talking a lot about trusts. We've talked about estate freezes. We've talked about various different methodologies. Oftentimes, the whole issue of estate freezes are enshrouded in mystery for many business owners, and oftentimes accountants and lawyers find it very difficult to explain how an estate freeze works. Here you have a diagram that I'd like you to explain for the benefit of the audience, please.
Sure. It's a little bit complicated when you start looking at the whole thing, but let's break it down into different parts. So at the bottom is the operating company in Canada. What we'd like to do is twofold objectives. First, we'd like to be able to claim the small business deduction. on the first $500,000 of active business income, but we can only do that if the OpCo is a Canadian-controlled private company. So when we are doing our estate freeze, on the left, you'll see the entrepreneur owns X million dollars of Class A, what we call super voting special shares. So the entrepreneur will have a formula that we build into the share provisions in the articles of OpCo that will always give him or her voting control. And so OpCo will be a Canadian-controlled private company able to claim the small business deduction on the first $500,000. At the same time, though, what we would like to do is to channel the growth in the value of OpCo. I think we've lost the picture there for a minute, Jeremy. The value of the common shares, we would like to be owned by a family trust. So when the picture comes back on, you'll see there's another arm going up on the right side of the diagram showing how we create another class of shares that do not carry the votes. Oh, there it is, the Class B common shares. So we've got two classes of common shares. We've got the Class A, and this is after the freeze, so all of the value of OpCo is taken up in the X million of Class A super voting special shares owned by the entrepreneur. We issue two classes of shares of nominal value. Class A common shares go to what I call the Capital Corp, another Canadian company, and under that arrangement, dividends can be paid on the Class A common shares, but the shareholder of those shares has no entitlement beyond the nominal paid up capital if OpCo is liquidated. To contrast that, on the far right, you see Class B common shares, again issued for nominal value up to the trust. And these shares do not entitle the holder to dividends, but like a classic common share, do entitle the holder to the surplus on winding up after entitlements are paid to prior shareholders. So what we've done with OpCo is we have created a situation where there will always be voting control in the hands of the entrepreneur, but we have two channels, one for dividends going up the Capital Corp, and the other for the increase in the value of the equity going to the family trust. And now the top part shows that the family trust is a common shareholder with voting common shares in the Capital Corp. So let's say that the operating company has paid its tax and it has surplus available. We want to maintain the lifetime capital gains exemption. We want asset protection. So we pay a dividend not greater than the safe income of OpCo up to the Capital Corp. And we can do that without any tax in the Capital Corp. And the Capital Corp now is controlled by the Barbados Trust, which under the Income Tax Act is still going to be considered a non-resident owner, even though for purposes of computing worldwide income, the Act will say that the trust is deemed to be resident in Canada and has to file a T3 return. For this purpose, for ownership purposes, it is a non-resident of Canada. And so the investment income earned in the Capital Corp is treated very differently than would be the typical case where an entrepreneur has control not only of the operating company, but also the holding company. We don't want the investment company to be a CCPC, a Canadian controlled private company, because investment income is subject to two layers of corporate tax. The first is the regular federal corporate tax of 26.5%, and then the federal surtax of roughly another 24% on top of that, applicable to a CCPC. But the Capital Corp is not a CCPC, and so we do not have that additional corporate surtax. Therefore, the only tax on investment income in the Capital Corp is the regular federal surtax of 26.5%. Now, overall, what have we accomplished? We've got a trust in Barbados providing the best asset protection available, as we've discussed before, with the best fiduciary available. That's Eticas, managed by John McLeod. We have done an estate freeze in the operating company, fixing the value with super voting shares, so the entrepreneur is passing on future growth to the next generation. We've got two channels, one for income and one for equity growth. The income going to the Capital Corp, equity growth going to the trust for ultimate disposition. If the shares qualify as qualified small business corporation shares, we can get the lifetime capital gains exemption and possibly multiply that exemption if we have family members who have allocated to them capital gains. And we have the ability to reduce the tax on investment income by 1/2 down to 26.5%. That's our sort of ultimate estate planning structure.
Thank you very much, Lorne. I will say that a Barbados trust isn't right for everyone. However, where there is a need to achieve superior asset protection, and again, stepping back to the theme of our program today, in anticipation of a wholesale level of insolvencies, we're not only concerned with our clients' businesses, but the clients of our clients. Are they able to pay their invoices? Are our clients able to collect on receivables? It'll depend very largely on the question of whether or not their clients will remain solvent. It's estimated that large numbers of companies that have had to close may never reopen. And the whole issue with creditor proofing, as John mentioned previously, is that you mustn't have a situation that's imminent where you have collection efforts being made in an effort to try to achieve superior asset protection. One of the key elements of this concept is, again, segregating assets, active from non-active. Since in Lorne's illustration, there's contemplation of paying dividends each year from the operating company up to the Capital Corporation. The Capital Corporation, again, is a company that would not require a small business deduction, would not require a capital gains exemption, nor would qualify for either. Since the controlling shares of the Capital Corporation are held by a family trust in Barbados, the common law principle of central mind and management, or central mind and control, in this case, would state that the common shares, the controlling shares in this case, are held by, are controlled by individuals in Barbados. Therefore, we're opting out of a Canadian-controlled private corporation. What's noteworthy is that it's a trade-off. We can decide to use a Canadian corporation, a Canadian-controlled corporation, or we can opt for a Canadian corporation which is not controlled by a Canadian, meaning a non-CCPC. The difference is that with respect to a CCPC, Canadian-controlled private corporation such as OPCO, you have the benefits I've already described, whereas there is a downside in some instances, and that is that a Canadian-controlled private corporation has to pay federal refundable tax or surtax, which means that depending upon the province, the tax rate on passive income, meaning income that's earned outside of active business income, such as investments, is taxed at well over 50%, 50.07% in Ontario, and it may vary slightly in different provinces, but it's over 50%. The difference is, and the reason that it's so high is because of the fact that there is this federal refundable tax that one has to pay. Some people would ask, well, is there concerns over Carr with respect to this? And of course, one of the three tests that we would focus on, and we'll focus on that alone for today, because this discussion is outside of the scope of this conversation, but was there a bona fide reason for this transaction? And in this case, the bona fide reason that we would look to would be asset protection. The fact that there is no refundable tax is a side effect and the trade-off that one would consider when determining whether or not you establish a CCPC or a non-CCPC. So the whole question of how we can help companies who may be facing a litigious situation, we expect the creditors of companies in Canada are going to strike fast and strike hard. We believe that because they'll want to protect their own interests. So it's important that if you haven't done an estate freeze and you haven't set up a structure involving benefits and provisions that are made through the use of a family trust, as an example, you consider doing so now. And for those people who have done an estate freeze in the past, and they say, oh, we've already done that years ago. Lorne, I'm just wondering if you have any comments for individuals who might have done an estate freeze in past years and feel as though they've already been through this and there's no need to do anymore.
I'll go back to what John was talking about earlier and just to underline how important it is to look at the fall in value. Let's say you did an estate freeze a few years ago and the value of the company has fallen by 50%, as Todd, you also mentioned from our previous discussion. So if we were to do a refreeze today, in other words, we would exchange the existing freeze shares for new redeemable preference shares based on today's fair market value, which is equal to, in this example, 50%. What happens when there's the recovery that we're all expecting to happen when the pandemic is over? The interesting part here and the real opportunity is the recovery back of that additional or that original 50% back up to where the company was frozen 2 or 3 years ago. Instead of that being subject to capital gains tax, because we've done the freeze, that is accruing to the next generation. And so we have permanently avoided tax on that recovery of the 50%. So now is a good time not only to initiate an estate freeze, but to consider a refreeze where values have fallen and we can improve our estate plan and give, based on today's discussion, superior asset protection as well.
Well, thank you, Lorne. John, I was curious just to ask you, I mean, we're setting up a trust and we realize that in the case of this estate freeze model, the trust itself would hold shares of a Canadian corporation, a corporation resident in, say, Ontario or British Columbia, Alberta, or wherever our attendees are from today on this program. And we also realize that there's no assets being sent to Barbados, other than the fact that the Barbados Trust would be holding the shares. As a starting point, what would you say to apprehensive business owners, entrepreneurs, accountants, lawyers, who may have some concern about having shares of their corporation held by a trust thousands of miles away by people that they've never known?
Well, you know, surprisingly enough, that's not the first time I've heard somebody ask that question. There's about 5 reasons that somebody should take some comfort in transferring assets to a trustee, and that they should take comfort in the fact that the trustee will ensure the best interests of the beneficiary. You recall earlier I said the sole purpose of a trustee is to benefit beneficiaries and nobody else. Number 1 is the fact that every trustee at law has a requirement of duty to the beneficiaries. Number 2 is that in most trust structures, the clients that settle these trusts appoint a protector, and the protector has the ability to remove and replace the trustee at any time. So while the settlor or the entrepreneur can't control the trust or the trustees, he has the ultimate influence in that he can fire the existing trustee and appoint a new one through his protector. And his protector could be an individual, a corporation, his brother or his brother-in-law, whomever he wishes. And having that person in Canada should not taint the trust structure in any manner. Number three is most people, when they set up such a trust, provide the trustees with a letter of wishes, which outlines how the settlor would like to see various situations and matters handled. Number four, the regulators in all major trust jurisdictions have the ultimate control and authority over the trustees, and should a settlor or a beneficiary be concerned about activities of or some of the trustees, then the local regulator can be advised and will take immediate action. And I guess number five is that the courts over the last 900 years have put a greater standard of care and duty on trustees, particularly professional trustees, than, for example, an individual trustee. And that's probably the reason why so many people are moving away from the husband and wife in the home jurisdiction being the trustee of the trust and appointing a professional trustee in an asset protection jurisdiction, because they know that the standard of care in the courts will protect their interests. Not that, in the 25 years that I've been working in this area, I could count the number of times there's been a challenge on one hand. So I think the message behind all of this is careful planning, using people who have experience in setting up these structures and know what all of the pitfalls are, will bulletproof the assets for not only this generation, but what I hear from entrepreneurs, well, up until a month ago, was I'm not worried about getting sued, but there's no way I want to have my future son-in-law or future daughter-in-law of getting their hands on any of my assets after I'm gone. It's slightly different now because there's a greater level of concern about this generation and potential for insolvency.
Brian, I think you need to unmute yourself. No, still not working, Brian. Jeremy, can you help Brian unmute himself?
Yes, there we go. Because I was muted by the organizer. I would only draw attention to, I guess it's a case called St. Michael's or Garon, to make sure you do ensure that you set up these trust arrangements, that you make sure that the trustee is the one calling the shots and not someone else. It's a very unfortunate case where the Supreme Court of Canada endorsed a decision of Madam Justice Woods at the tax court, who held that because the, I guess is one of the beneficiaries, the settler of the trust, in vernacular, did not leave well enough alone, and the trustee paid attention to that settlor, that the trust was really resident in Canada. They really applied the corporate law test of residency and held that a trust is resident where the decisions were made. Up till that point, people said, well, stated the black letter law that a trust was resident where the trustee was. And the Supreme Court of Canada said, no, you have to look at where the decisions are made, just like corporate residency, and a trust is resident where the decisions are made. And in this particular case, the court came to the conclusion that the decisions were made in Canada, not in, I think it was Barbados.
Very good, John. Sorry, Brian. Brian, further to that, there's been some discussion as to, and Lorne, I think you wanted to make a comment about the issue of residency. And I'll just finish asking Brian about the way that the trust might deal with situations such as a court, when would a court break a trust? I mean, John has mentioned about providing protection for the assets, assuming we have a fully discretionary trust. And in what instances do you think there may be risk that that a court may decide to make an award to break a trust? And then Lorne, we're coming back to you afterward. Please, Brian.
Well, I think that's not a little bit out of my area of what I usually do, so I'm not going to try to answer that one, Todd. Lorne, you want to try that one?
Sure. Well, I'm going to start with how John has described his practice with Eticas in Barbados to be the legal owner of the trust and to make the decisions there in consultation with the family and being accountable to the protectors for the benefit of the beneficiaries. That is a compliant, strong structure. The courts have traditionally respected compliant, strong trust structures. They, however, will look at all of the facts, and in particular, if we're looking at a matrimonial dispute or where there's an insolvency, those are courts of equity as opposed to pure black letter law courts. And when a court of equity is asked to look at a situation, they take into account the behavior of people. So where there have been a few examples of a court breaking a trust, inevitably somebody has misbehaved. So in one example that I can think of, there was an estate freeze and succession plan where the father was transferring ownership and control of a family business to the son. The son and the wife had a matrimonial dispute, and the wife sued to get an equalization payment from the increase in value of what the husband had inherited as part of the succession plan. The husband denied the existence of the transfer, saying that the lawyers and accountants hadn't recorded it properly, and he really didn't have control. The courts rejected. They saw the minutes of meetings and the record of payments that contradicted the assertions by the husband, the son. That kind of misbehavior was the key to open the door to the trust, and the wife was awarded an equalization payment. So when we're doing our estate freezes and we're using trust, we have to consider, will a court respect the trust? We have to respect the trust, and then the courts will. If we don't, if we misbehave, if we dissipate assets purposely so that an unhappy spouse will be disentitled, or if we control the trust, in fact, as in the Garin case that Brian was alluding to, we're not respecting the proper structure, and the courts will not either. So in short, the courts are reluctant to break a trust, but they will do so if there's been misbehavior.
And Garin was a situation.
Although there are conventions between various jurisdictions, sometimes a domestic court in one jurisdiction cannot do what it intends to do in another jurisdiction.
Right, and I guess the important thing to keep in mind with Garin is that we're deciding on the taxation of the income. And in that case, the Tax Court of Canada can make any decision it wants, and then whether that can be enforced, I guess, is another issue. There's a very broad principle that I derive from the Garon Trust. The thinking was, or the view of practitioners was simply that the trust is resident where the trustee is. And they came to that conclusion from reading a case called Thibodeau, where the court considered all the issues and considered the facts and came to that conclusion. But people always like to simplify things and put them in a nice little rule, and so they adopted the rule, well, the trust is resident where the trustee is. When you go back and read Thibodeau, it doesn't say anything nearly that broad. And when Garin came before the courts, the CRA presented it as a tax avoidance scheme, and the court seemed to be willing to seem to find a reason to impose tax, and ultimately settled on this issue of residency. There were some unfortunate facts that happened in between. My understanding is that most of the activity were in corporations down below, where there's clearly demonstration that those activities were in Barbados, but there wasn't much at the trust level that pointed to the trust being in Barbados, and the court was able to conclude that the trust was really resident in Canada. So just another lesson in first of all, looking at all the facts, looking carefully at the case law you're basing your planning on, and then documenting it properly.
And what's interesting is if you look at the diagram that's before us now, that is a conventional intergenerational estate plan. And so the documentation talks about intergenerational estate plan and passing assets on to future generations. And there's no mention of income tax anywhere in this diagram.
Very good. I would like to, at this point, summarize by saying the time to achieve asset protection is now. The time to purify a company is not at the time when you have a buyer at your door. Since the values are down, even if you've done estate planning already, it's time to revisit it. So we're urging accountants and lawyers who are in attendance to take heed of some of the suggestions we've made, because oftentimes the planning and the result is very severely prejudiced by the outcome. And all one has to do is sit in at the Tax Court of Canada and listen to various cases that are being heard. If you think that it doesn't happen, it's kind of like some diseases that people believe only happen to other people. Same thing with issues within families where you have creditors such as family members who are becoming disgruntled, marriage insolvency, marriage breakdowns, which can result in certainly a creditor that could attach assets. The fact is that this is a time where some of our clients are in a position to save possibly millions of dollars by affecting an estate plan, including an estate freeze involving trusts at this critical time. At this point, I'd like to turn this over to Jeremy. And Jeremy, I believe, according to the notes I'm seeing on my screen, you have some questions from some of the audience members.
Yes, thank you, Todd. We have one question from a viewer regarding the corporate structures and the costs versus the tax benefits that they provide. He says, many interesting organization structures. However, what type of considerations go into creating such complex structures which increase ongoing costs versus tax benefits?
Who would like to take a run at that question?
I can take one shot at it, and Lorne can go. I mean, obviously, that is always a trade-off. Certainly, in my own personal life, have traded off whether you want a very complicated structure that'll save a little bit of tax at a huge cost of organization, compliance cost. So you have to take that into account, and rather, I guess I'm saying rather the obvious, but the more assets you have, the more likely it is you're prepared to bear the costs of setting up structures that do take money to set them up and take money to make them compliant. But for a few $1,000s in assets, no. For a few $million in assets, yes. So somewhere along the line there is a dividing line, and a proper and a good counsel, a good accountant will guide the taxpayer to decide whether it's worthwhile setting up complicated structures that require a lot of maintenance, or whether it's just simpler to go along and pay your tax, or do a different structure. I get this a lot of the time outside of the estate planning area in people who want to set up offshore corporations and deal with our FAPI rules. And people don't recognize that if you're going to set up an offshore structure, you have to have directors who are offshore. you have to have somebody maintaining the corporation offshore, and there are generally significant costs. And if you have a multinational, it can easily bear those costs. A small person running a factory here in Toronto probably can't bear those costs. So again, it's always a trade-off as to what to do.
I'll just add to what Brian is saying. I try to explain to clients there will be upfront costs. You'll pay legal costs for us structuring it. You'll pay John setup costs for the trust and annual costs to maintain. But what you have to look at is amortizing the costs over the life of the structure. The trust can last for 100 years, and we know that there's a 21-year deemed disposition rule in Canada we have to comply with, but it's a very long period that I would suggest is the amortization period for the costs. And then the benefits are derived from principally the asset protection and secondarily tax savings through the freeze, shifting the growth to the next generation, and then through that more complex structure I explained, reducing tax on investment income by 1/2. And an example that John and I are currently working on, a real estate owner sold a couple of buildings and after tax had $45 million available. And I worked with his accountant and we looked at a comparison. What if he did nothing and simply put the money into an investment account in Canada, earned income and paid tax, versus going into the Barbados estate-free structure with a capital corp that is a non-CCPC earning the same investment income. And the result was over a 25-year period, the Barbados structure was better by $7 million. So it was a very significant benefit that convinced the client it's worthwhile going ahead and incurring the costs because the long-term benefits are very significant.
One other point I'd come back to in terms of pros and cons is what is the payback period? Because if you're doing this thing for tax reasons as opposed to creditor proofing or estate planning reasons, there's always some risk that the tax rules will change. You'll do a plan to take advantage of tax rules only to have the government recognize that there's a tax, call it loophole, a tax advantage that shouldn't be there, and closing it off. Reminds me of a story in which there's a well-known practitioner who had a almost complete manuscript on the Estate Planning Act. Estate Planning was the State Tax Act back in 1971, just before the capital gains came down. And then I think it was something like June 18, 1971, the government of Canada proposed to phase out the Estate Tax Act. And so that manuscript was now worth about nothing. And so you do have to take into account what is the likely payback period. If you're looking at something that has to stay in existence for 10 or 15 years to pay back the tax, well, maybe you don't do it because there's a good chance that the plan will be changed or the rules will be changed before you can do that. If you can get it paid back in a year or two, then more likely you do it. Always a trade-off and always taking into account all the issues.
I thank you, Brian. I would also add to what Brian and Lorne had said, that no solution is a one-size-fits-all. It's a question of determining what is the best solution for a particular company. And many companies that are more modest-sized businesses ought to still be doing the estate freeze. It may not be necessary to do something nearly as exotic. Having said that, the kind of planning that we're talking about does not require that much in the way of fees relative to what one might think. Since in this case, the Barbados Trust is only holding shares. There's no corporations set up in Barbados. There's no money sent to Barbados. And in this case, it's a question of shares of a corporation being held there. And by achieving this type of involvement in a trust, it doesn't it's not nearly as expensive as what one might think. And basically, one of the things we do is a very in-depth analysis. And we say, well, what is the tax cost to do this? And what is the cost of doing the planning? And generally speaking, if there isn't a much greater reward, we won't recommend it. So there's solutions for very modest companies that want to do an estate freeze, that recognize the need, that want to save taxes by reducing the value of the shares they hold and passing the rest of the family to multiply capital gains exemptions. So
Todd, I've got an example that might clarify your point. A few years ago, we met with a relatively young entrepreneur who had an industrial supply business that was probably worth $1 million or maybe $2 million at maximum at that time. And we decided to do an estate freeze, and we did do a trust, and the trust happens to be in Barbados, although we could have had it anywhere. And we cast our minds forward to today, and several things have happened. Number one, the client involved is looking at an offer to buy his business, which will increase his gain on the common shares by a good $10 million. Now, he has a wife and kids and so on, so there are 6 beneficiaries, if you will, each getting their $860,000 of lifetime capital gains exemption through the trust. We've also kicked out the other tax considerably by moving it out of generation. And coincidentally, there's also some matrimonial properties issues on the scene at the moment, and we now have an asset protection structure that should be very resilient, and we also have a very, very, very successful tax outcome. And Lorne's familiar with the file as well, so any comments that you'd like to make, Lorne, please feel free.
Sure. In that example, we have the added feature. A lot of Canadians have assets and family members outside of Canada, maybe in the US. In this case, the entrepreneur is American, but the rest of the family are Canadian. So in the trust arrangement, a typical Canadian trust isn't going to work for an American citizen living in Canada. We had to consult with US tax counsel to make sure that the trust we set up was neutral for US tax purposes, and that if there was any Canadian tax payable, the entrepreneur who would have to file a US tax return could get a credit for Canadian taxes payable against his US taxes payable. So in our structure, we, at the time, 3 or 4 years ago when we set this up, we were doing so for protection, estate planning, taking into account potential matrimonial issues, and US beneficiaries. So we had to take all of that into account, and it's turning out to be a successful estate plan.
And that was a very modest business when we put the structure together.
So there is a solution. Jeremy, go ahead.
Yeah, we have a number of more questions from the audience. I apologize if we're not able to get to all of them. Should we move on to the next question?
Yeah, before we do, I noticed that we're coming close to the end of our program. We have 6 minutes left, and we'll answer whatever questions we can in 6 minutes. We would like to ask everyone to please give us your feedback. Your view of what we're doing through this program is very important. We haven't charged for it. It's not our intention this time to do so. It's our intention to continue to bring value, bring assistance throughout this period that can help advisors and business owners alike to navigate some very challenging times. We have a number of subjects that people are asking for. Tax dispute. Clearly, there's a lot of expertise within our panel on litigation and other tax matters. Companies that have assessments that are in the tune of several $100,000 and more sometimes millions of dollars, in the past were not a concern. Now it's a concern. It's a sum of money that the company can't afford to pay. How do you best deal with tax disputes, even though it's on hold? Incentive programs. We've had requests for incentive programs, such as the government's scientific research program and other issues, too numerous to mention, including trusts and a more deeper dive into a technical analysis on trust, how to use trust to better safeguard a number of different assets, how to move money from other countries to Canada on a tax preferred way. So we'd like you to please tell us what you want to hear about. We'd like to hear your feedback, whether this information was useful and where you'd like us to go from here. You'll be also getting an invitation by tomorrow for the next program, which is tentatively scheduled from a week from now. But anyways, let's finish off with the questions. And before we do, I want to thank everyone very much for staying with us. And I noticed that the attendance is strong, and we really appreciate your involvement. And we're here to support you in any way we can. Jeremy, please proceed with the questions.
The next question is, can you please explain how OPCO remains a CCPC if its shares are owned by a non-resident Barbados trust? And I think he's also asking about the capital corporation as well.
Lorne, do you want to address that?
What I mentioned and what is shown in the diagram, the OPCO's control lies on the left side with the entrepreneur holding super voting special shares. The fact that the OPCO has issued common shares that have nominal votes to the Capital Corp or Trust does not in any way detract from the control of the operating company by a resident of Canada. So OPCO remains a CCPC.
Thank you, Lorne. The next question relates to the cost of Barbados Trust. What are the ongoing costs of establishing a Barbados Trust?
I guess I should answer that, being the resident Bajan here. The costs of setting up a trust depends on the complexity of the trust and so on and so forth, but it's rather insignificant. It ranges between $4,000 and $6,000 is the fully loaded cost that we as trustees would expect to see from the settlor or the contributor to set the trust up. And then there's an annual fee that we charge for administering the trust. And again, the way you do your fees is, well, there's several ways. You can either do a fixed fee or what's called an ad valorem fee. And it was interesting. I had a conversation this morning with somebody who were putting a trust structure together for, and the investment manager was going to charge him 120 basis points based on the assets to administer the investment portfolio, and the trustee was charging only 40 basis points. In other words, 0.4% of the value of assets to be the trustee, the ultimate beneficial owner, provide the tax plan and everything else. So the costs of international trusts are far lower than the costs of the average Canadian trust. And although we talk about Barbados trusts, sometimes we decide to use other jurisdictions because our group of trust companies that I chair are around the world, and there are sometimes reasons why we might select a jurisdiction other than Barbados, just FYI.
Thank you very much, John. A question related to back to the diagram that everyone can see. It has to do with the dividends. It says, why are the dividends paid up to Capital Corp? Why are they not impacting the capital gains exemption and the QSBC status of OPCO's shares?
Perhaps I'll answer that. So the dividends that are paid to the Capital Corp are done in such a way as so that we have two different conduits. One conduit would be for the purposes of purifying OPCO. The other conduit would be for the accrual of capital gains by the family trust for the benefit of the beneficiaries, being all the family members, including the entrepreneurs. So in effect, what we have achieved through the issuance of dividends through directly to the Capital Corp is in fact the eligibility for the QSBC status of the OpCo. Whereas since the Capital Corp is in fact not a QSBC, well, there is no requirement to worry about having the accumulation of cash dividends building up inside of the Capital Corp.
Thank you very much, Todd. This might be our last question. The question was there not supposed to be something on reducing passive income? I thought this related to the new rules on the 50,000 passive income. Not sure if he's referring to the grind down of the small business deduction, but we'll open that up to the panel.
I believe that the answer is that the reduction on passive income would be the fact that there's no federal refundable tax in this particular case, no surtax, meaning that the rate of tax that's paid on passive income or investment income in the Capital Corp is reduced to only 26% versus over 50% if it were held inside of a Canadian controlled holding company or other sort of company in Canada.
Thank you, Todd. It's now 3:01. Todd, what would you like to do?
Well, I'd like to thank everyone again for their indulgence. And again, Jeremy, please ensure that everyone has a form. Can it be displayed, Jeremy, or sent to them to fill out and send back?
Yes, I'll show everyone very briefly how to leave feedback. Just one moment. So here's our feedback form. I've copy and pasted this link again to our chat. So all you need to do is click on that link that I posted on the chat, and you should be able to leave feedback. Yeah, there's just a little bit of information that we asked for, and we greatly appreciate that. The other item that I would like to invite all of our viewers to sign up for is called our Tax Assist program, which you can see here on our website. Now I'm going to be sending out a link to this as well. This is a service that we offer at the moment free of charge to accountants, lawyers, and business owners. The purpose is to answer tax questions that you may have, and we have lawyers that will research the question and get back to you. Usually it's at no cost unless it's something particularly complex that might require further research. So this is something else that we'd like to invite you all to join as well.
Great. Well, thank you very much to everyone in attendance and to our distinguished expert panel for participating in today's program. We look forward to hearing from all of those in attendance with this input. Thank you.